guys. I wanted to introduce the next week civil rights and civil liberties, and I didn't get a chance to do a video before I went on vacation for elections and campaigns, but it seems like everyone got it sorted out, so that's good. When we're talking about civil rights and civil liberties, they are two separate things, but there is overlap. When we discuss civil rights, we're talking about people the rights of people to be treated without unreasonable or unconstitutional differences. So that can look really different depending on what we're talking about, because we can classify people into different categories and it isn't considered unconstitutional. For example, with taxes, we classify people based upon how much money they make. And so we put them in a certain type of tax bracket. That would be an example of a constitutional way to distinguish people. The test is that it cannot be unreasonable or arbitrary. And that's what the Supreme Court has said in past cases regarding a test of when you can classify someone as or when you can distinguish people into different classes. So previously, you could distinguish people in different racial groups for the purpose of college admission, and in the Harvard case, that was thrown out by the Supreme Court. So what we call affirmative action is now no longer in practice. They cannot use race as a determining factor for college admission, but they can use other factors that may lend itself to having a more diverse student population. So when we think of civil rights, we think of the civil rights movement is largely what comes to mind from our history classes or our government classes. So Martin Luther King Jr. marching and speaking, the I Have a Dream speech, out of the civil rights movement, we had the Civil Rights Act be passed and the Voting Rights Act come out of this. But that's not the only civil rights movement that we've had. It's just the one that we think of, and that's what we call the civil rights movement, or the movement to improve the rights of African Americans and minorities in the 60s. We consider that the civil rights movement. But there have been other movements, for example, the second wave of feminism, the LGBTQ or gay rights movement that happened. So the second wave of feminism we largely saw in the 70s, but it did start in the 60s and sprung out of the civil rights movement. And then same with the gay rights movement. It started at Stonewall and really continues. All of these are really continuing to this day in various formats. We might think of now as being, we're in a third wave of feminism after we had the Women's March on Washington in 2017, after Trump's inauguration. And so there's some debate among political theorists if we are in another political realignment and living in a new wave of a civil rights movement for lots of groups. So don't think about it just as specifically related to the 60s, because that isn't the case when we talk about civil rights. Civil rights are something that has spanned across our country's history. We just don't call them that necessarily. So when we talk about the civil rights movement of the 60s, so let's look at that for a moment. When Reconstruction began after the Civil War, African Americans saw their rights improve during that period until Lincoln's assassination. And then when Lincoln was assassinated and Andrew Johnson became president, things really changed. His vice president, Andrew Johnson, who became then president, was not as open helping African Americans advance economically, politically, any of those things. So we saw at the beginning of Reconstruction an increase in African Americans being voted into political offices, them being able to buy land, and then that being taken away pretty quickly. So that's when we enter the era of Jim Crow, and we see things like Plessy versus Ferguson, where separate but equal was constitutional, and that came out in 1896. And we have groups forming to try and challenge and change these laws. And of course, that takes a lot of time. One of the groups that's worth noting is the NAACP, the National Advancement. Now I can't remember what it is. You'll have to fact check that and let me know, because now I can't remember what the other A is. And I think the CP is colored people, but I'm not sure. They worked the courts to find kind of the perfect case to help end segregation. And this is one of the things that I don't know if we necessarily realize as we're going through this and looking at Supreme Court cases, but cases can be essentially manufactured. So if you remember when we talked about the Supreme Court, we were talking about how you have to have standing and the court has to have jurisdiction. So there has to be actual harm. And the NAACP, the NRA, the ACLU, they all have done this, and you can do this. There was a period of time when you weren't allowed to, but now you can, where you can essentially manufacture a case. And Plessy versus Ferguson was actually a manufactured case as well to try and end segregation, which it backfired, obviously, because then it said separate but equal is fine as long as it's actually equal, which we knew that it wasn't. So they looked around, and they would even advertise for cases, like in newspapers and things like that. And they were looking for kind of the perfect case where you met the criteria for jurisdiction and harm and standing and all those things that you have to meet. And that's when they found Brown v. Board of Education. And there's actually 2 Brown v. Boards of Education. We're not going to go into the weeds with that, because at the end of the day, like, what's important is the outcome, which is you cannot have separate educational facilities because they are inherently unequal. So they were able to show in Brown v. Board that it didn't really matter that they made them separate. They weren't inherently ever going to be equal. And so that's where the Supreme Court under Chief Justice Warren ruled, okay, then, we can't have separate educational facilities and you have to integrate. And you have a lot of cases that come out of that. Cases around busing. You have the issue with Arkansas's governor not allowing, children to go into the school, and him calling in like the police, or barring them, like himself going in and physically barring them as well. And Eisenhower had to call in the National Guard, and you guys have already learned about that. But you have a lot of cases that come out of that, and not just cases from the South, but also from Boston and New York City. And those are where you kind of get those busing cases. One of the things that also happened during the Jim Crow era, and even into the 40s, and actually FDR was part of this, is what's called redlining. And there's even a book, and you can read it if you're really interested in this. Basically, it was trying to increase home ownership, but only for certain groups. And that meant primarily for white people. And they had the home insurance that they were doing. And the home insurance, what they would do is they would draw red lines, and around largely African American communities, and those red lines were considered uninsurable. So you couldn't really get home insurance in that area or really get a mortgage, because a bank isn't going to lend you money if you can't have home insurance, because then if your house burns down or something happens to it, then you're not going to be able to pay them back. Basically, they want to, cover their butt. So you had these areas, and they were called like redlined areas, where you couldn't get home insurance. And that was a real problem for African Americans being able to get on the property ladder. And you'll see in one of the documentaries that you watch from the Netflix Explained show how this affected the racial wealth gap. So all of these things are kind of coalescing in the 60s. You've got Brown v. Board, redlining, African Americans trying to end housing discrimination as well. So there was a case that came out in 1971 called Swan v. Charlotte Mecklenburg Board of Education, and that set out the guidelines for cases that would follow regarding school segregation, because Brown was not very clear. And then when Swan came about in 1971, they showed, the Supreme Court actually put a test out there for future cases, all right? And as I said before, like, one of the things that was a big issue was busing, because with the segregated communities, because we had housing discrimination and you couldn't get home insurance, you had groups of African Americans living in an area and then groups of whites in an area, and really the two did not intermingle or mix, as far as like you didn't have a lot of black people living in the white area and vice versa. So that created issues around school integration, because you would have an area and it's its own school district and it's primarily black or primarily white, and that's because that's who lives there. And so busing became an issue. And one of the cases actually came out of Boston. So even though we think of this as like a southern problem, the northern states were not immune from this in any way. So we have court cases that come out of the Supreme Court on one hand, and then you also have the legislation that comes out as well. So the Civil Rights Act, the Civil Rights Movement, those types of things. One of the things that happened during this time is you see the Supreme Court, really move to what we would consider the left. Okay, so this is the time when Roe v. Wade. This is the time of Griswold v. Connecticut. This is the time of Brown v. Board. The Warren Court is really what we're talking about here, okay? That legacy, all right? And this is when Michael Waldman was talking about how in the 70s and 60s, 70s, and during the Civil Rights Movement, the left, the liberal side of the political spectrum, was in love with the court, and they thought they were like guardians and saviors and things like that. And now we're saying that that was never, should not have been the case. It was a quicker way to move to get people protected and to end discrimination, to end practices that we would consider unconstitutional today with no questions asked. It was very quick to do that, but it doesn't provide the safety net that we expected. And we see this in the Dobbs case with Roe v. Wade being overturned. And in that decision, the Supreme Court pretty much invited cases to come before the court to challenge gay marriage, to challenge really any kind of right to privacy. So when we think about the Dobbs case, it isn't just getting rid of abortion, it's really putting the right to privacy on very thin ground, basically, just to get you guys thinking about that. All right, so when we talk also, we're thinking civil rights movement, you have these Voting Rights Act being passed. Those really have for a long time stood the test of time, except the Voting Rights Act, because we have Shelby County v. Holder in 2013, which really gutted the Voting Rights Act. And so you've got a big push now on the more left-leaning side of the political spectrum wanting to do essentially like a new Voting Rights Act to kind of undo what the Supreme Court did in Shelby County. In the Voting Rights Act, if a county had a history or a state had a history of racial profiling or discrimination, so largely in the South, then they had, if they redrew the voting district, it had to be approved by the court. And the Voting Rights Act basically tried to ensure that there wasn't racial gerrymandering, which was considered unconstitutional and still is. Of course, it still happens, but we can talk about that later. So one of the things that Shelby County did is basically say, racism is dead. It's not there anymore. These counties, they don't have to do that. So we're going to just let them not do that because they don't have to. And that, of course, is a huge issue with voting rights movements, people who want to make sure that people are not disenfranchised and that they're able to access voting. And then so we're going to move on from the civil rights movement and we're going to move into the women and equal rights. And so we have women getting the right to vote in 1921 with the 19th Amendment. So women have had the right to vote for just over 100 years. Women being able to have access to birth control and things like that have only been since the 60s and 70s. What really sparks the women's rights movement is it comes out of the civil rights movement, but it becomes its own movement when it becomes very apparent that the civil rights movement is really meant to like protect people of color, particularly African Americans, because that's who was marching and things like that, but they're not the only minority at the time, right? And so the women's rights movement gets sparked during that. Betty Friedan in 1963 wrote The Feminine Mystique, and that kind of helps spark that second wave of feminism, and it grows out of the civil rights movement and becomes its own movement. So you have laws being passed in Congress that ban discrimination on sex, pregnancy, you have Title IX that affects schools, and then you have Supreme Court cases for access to birth control, abortion, those types of things, okay? Again, with the Dobbs case, that has undone a lot of that, but not all of it. So regarding the base, like discrimination based upon sex, I want to clarify something. When we are talking about this, we are not talking about sex as in, am I a man or a woman, okay? When we talk about sex, we're talking about the biological parts. Are you biologically a man or are you biologically a woman? That is the medical term that we use to separate men and women. All right, now I know that there's a lot of movement around like not identifying as a man or a woman. That's not what we're talking about here, okay? Gender is the social construct. So sex is the medical, gender is the social, okay? So I could be as a sex, a female, but I might identify as male. And that's based upon social constructs when we talk about gender. Right now in the discussion, those two are being conflated as one, and they are not. So it's really important, and this isn't to be anti-trans or anything like that. It's just we need to distinguish that for the purposes of this conversation. We're not necessarily talking about gender or trans rights, because at the time, those were not included in these cases. Those are coming, that you'll see come out of very likely this wave of civil rights movement that we're seeing again. But at this time, we're not talking about that. So to discriminate based upon sex, there is a test that the Supreme Court set out. And it's called the strict scrutiny. So you have to look at like, okay, what is arbitrary, what is reasonable, what is unreasonable, and those types of things, okay? Because we can discriminate on age, you know, the drinking age, for example, and now the smoking age, mandatory pregnancy leaves, unequal retirement benefits. Those are areas that are unacceptable by the court to discriminate on sex. Now we can discriminate on age, right? Because you have to be 21 to drink. You have to be 18 to vote. So we can discriminate on age, but not sex. So you cannot say that a man can drink at 18, but a woman has to wait till they're 21, or vice versa. Or a woman is 21 and is considered an adult, and a man is considered an adult at 18, or vice versa. You can't do that. That is unconstitutional. But areas that are accepted by the court is all boys schools or all girls schools, the widow's property tax, and the draft. Women don't have to register for the draft and men do. And there was a Supreme Court case that looked at that, and the Supreme Court said that that was constitutional, that women don't have to register for the draft. That we had affirmative action for a period of time. We're going to skip over that because that has been ruled unconstitutional. And so when we look at the next one, we're going to talk about the gay rights movement. And during the gay rights movement, Stonewall is really what kicked it off, as well as the HIV/AIDS epidemic. When HIV and AIDS started making its way through the population, it largely hit the gay community. I don't want to go into the reasons why, because we don't need to get in the weeds about that. If you're really interested, there is a film that you can watch called How to Survive a Plague, and it talks about the HIV and AIDS. And one of the things that happened is because it hit the gay community, there was very little federal funding to study it, to understand it. And so it killed a lot of people. That changed when it hit the white heterosexual community, because we know that HIV and AIDS can be transferred through blood, not just through sex. Like if you at the time they couldn't test for it, so people would get it through blood transfusions. So when white heterosexuals started getting it, then we needed to research it. But until then, it didn't happen. And so you don't really see movement on AIDS research until the Clinton administration, which was not that long ago. In 2003, we have the case of Lawrence v. Texas, which struck down sodomy laws. And you'll hear about this in the More Perfect episode of Imperfect Plaintiffs, so sodomy laws were basically a way to try and legislate what sex you could have. Like if you were two men and you wanted to have sex, that was considered unconstitutional, that was considered illegal. And then the sodomy laws were ruled to be unconstitutional. So if you were having sex with a man, before Lawrence v. Texas, potentially you could be arrested and charged with a crime. They were largely unenforced, but they did, in the case of Lawrence v. Texas, find a plaintiff, and they were actively looking for plaintiffs. They found one, and you'll hear about that in More Perfect, Imperfect Plaintiffs. I'm not going to go into that too much. Really what that Supreme Court decision said is that the right to privacy is not just about medical issues like abortion and contraceptive. It really goes towards the right of an individual, single or married, to be free from unwanted governmental intrusion into sexual matters. So that's what Lawrence v. Texas says. Now, those sodomy laws are still in the books, but they can't be enforced. In the Clinton administration, you have what's called DOMA, the Defense of Marriage Act, which basically stated that if one state legalized gay marriage, another state did not have to recognize that, which is a violation of our full faith and credit clause. Now, it was always going to be unconstitutional because it quite clearly violated the full faith and credit clause. And it was overturned in 2013 in the United States v. Windsor. It was overturned. And then in 2015, you have Obergefell v. Hodgins, where same-sex couples could be legally married in all 50 states. So that's pretty much the civil rights, civil liberties section that we need to look at. So remember, when we're talking about that, just as kind of a overview and summary, is we're talking about the civil rights movement, the women's rights movement, the second wave of feminism, the gay rights movement, and the cases that came out of that, and the legislation that came out of that. It's really important to note that when any branch of government delegates their power to another branch of government, you're going to have problems. Our system was not set up to be quick and efficient. It was set up to be inefficient for a reason. The reason being that we don't want our country to be caught up and swept up in some fashionable whatever and go off the rails. That was the whole point. That's what the founders were worried about, is the mass, the people. It's kind of like we're our own worst enemy, which is honestly very true. So when we look at how these steps were made towards equality, it's important to recognize that while it did achieve equality, it didn't necessarily mean it achieved lasting equality, because we're seeing how easy it is to undo it through the courts. So you're now seeing a push to legislate abortion rights, to legislate the right to gay marriage, to legislate the right to contraceptive, those types of issues, because it can be undone by a Supreme Court decision very easily. We're, in a sense, living in the backlash still of the Warren Court that was considered a very liberal court. It will be interesting to see what happens. We're about 4 weeks away from an election. So depending on what happens in that election, we might see some Supreme Court justices retire or not. So we'll see how that goes. Pay attention to the news with this stuff, because the Supreme Court is starting oral arguments again for cases, and some of those cases could be really, really important. There are some cases that came out in June. One is the Chevron case, which we'll talk about when we talk about the bureaucracy. But pay attention to those things, because even if we don't think that it affects us directly, it could. So with the Dobbs decision, for example, your right to privacy is now on thin ice, because basically the Supreme Court said, sorry folks, there's no right to privacy in the Constitution. So we have to pay attention to those things, that even if we disagree with it, does it protect the fundamental rights that we believe in? Or is it something that needs to, possibly go back to the legislative branch? And that's what we're seeing, right? Is like the Supreme Court not being the guardians and saviors that the left thought it was for these civil rights protections, and instead looking at the legislature and being like, we need to actually protect this and codify it under the law. Remember the quiz? All right, and then the next week is going to be criminal justice, and we will continue to crack on.